So I didn't plan on impeaching Marty going into the prelim because I wanted to save it for trial. I know that's a strategy call sometimes we make.
Mm-hmm.
But another tidbit that my client shared with me during my client interview was that Marty is a party animal and his nickname is Party Marty.
Stop it. Hey, are we talking like meth party?
Not meth, but cocaine, alcohol,
Okay.
stimulants, poppers, but when he,
Ketamine.
yeah, it's all it has some recreational allure.
Mm-hmm. Okay.
So when I saw the complainant was come in, he was all buttoned up, dressed nicely.
Welcome to Another Not Guilty. I'm David Moore, here along with my fellow public defenders, presenting to you the untold stories of the criminal justice system.
Objection! That assumes there's justice in the system, which there ain't. I prefer calling it the American criminal system.
These stories are about the not guilties public defenders get on a daily basis.
In an unjust criminal system.
With the deck stacked against us.
Welcome to another Not Guilty.
And welcome back, everybody, to Another Not Guilty. It's your boy, Davey D, here, bringing you the freshest not guilties across these United States. One not guilty brought to you at a time to show you that the government doesn't know what the fuck they be talking about all the time, and us public defenders gotta put them in check. That's what we do on a daily basis, and guess what? It happened again today, folks. We're going to present another story for you to let you know how we do it across these United States, these red states, these blue states, these purple states, these states of unitedness.
For as long as we still have
United.
them.
Did that sound like Barack a little bit? A little Barackish, right? Okay, that's right. And that, of course, right there, guys, you heard it, is Lauren. She's here today with us. She's on this justice train. Lauren, how you doing today?
Hey guys, I'm doing pretty good. Under the circumstances.
Yeah.
Trying to stay away from the news.
I think that's 2 episodes in a row where I think I really nailed that intro.
It
I
was
think I'm
pretty
getting
good.
I think I'm getting better at it.
I felt the energy.
Did you like that?
Yeah.
Okay, good. I know you're talking about the news. I don't want to gloss over that.
No. We don't need to talk about the news. I'm just saying.
Yeah.
I think we're all doing the best we
Yeah.
can given
Yeah.
the barrage of news stories.
You know, we're kind of addicted to the news. Like today I was like, you know what? I need my daily dose of bullshit. Let me go on the news and get upset real quick. Better now. Okay,
I
good.
like to get my panic attack out of the way first thing in the morning when I scroll through the news. That's done. We can move along now. Yeah.
That's right. And we got, of course, someone is here in the background, but let's bring him to the front. Our guest today is Glen O, all the way from Detroit Public Defender Services. Is that the title, Glenn? How you doing today? Introduce yourself to the A&G first.
Good, that's correct. We're called the Neighborhood Defender Service of Detroit. Our parent organization is NDS Harlem.
Nice. And your name is?
Glen O, yep.
Glen O. How long have you been a public defender for?
I've been a public defender for 5.5 years.
We've had someone from Detroit. We've had someone from the neighborhood before, right?
That's correct.
I
Blaze
feel like
Kearney
we've
and Hannah
heard
Berry.
that.
Blaze Kearney from the hood.
Alfred Hitchcock for the people, his murder case.
Defenders in the hood. You guys ever call yourselves that?
It's such
Definitely
a cute
not.
name.
Especially because Blaze is white.
It sounds so sweet though.
Yeah.
Just from the neighborhood.
Neighborhood.
Yeah.
It's
I like
your
it.
neighborhood defender.
It's very unassuming, and then you come in with the fire.
That's right.
Mm-hmm.
I like it. That's right. All right. Well, Glenn reached out to the podcast. He's a fan. He said he wanted to be on the show. And I said, of course, Glenn, you're a public defender. You're a defense attorney. And you fight for our clients. You fight for the community. You fight for the people of the United States. So, of course, you can come on the podcast. So, Glenn, thanks for reaching out and being on the podcast today.
Happy to be here.
Right on. All right. So, Glenn, tell us about this trial you did. You had a client. You represented him to the fullest. He was charged with something at first that the government got it wrong. What was he charged with?
So he was charged with 2 separate cases. Each case had 3 counts. The first was count 1, aggravated stalking. It's a 5-year felony. Count 2, domestic violence, third offense. It's a 5-year felony. Count 3, felonious assault with a knife. It's a 4-year felony. And then there was a second case which occurred 4 or 5 days later. And in that case, he was charged with home invasion first degree, which is a 20-year felony. Aggravated stalking again, which is a 5-year felony. And then domestic violence, third offense, 5-year felony.
Okay, is this all the same alleged victim?
It's the same complainant on 2 different dates.
But we also have the same alleged victim with the domestic violence charge and an assault charge. Is that for the same conduct, or were they alleging separate acts?
So for the first case, it's domestic violence, third, and felonious assault, but they have different elements, so they charge them together whenever there's a dating
relation.
relation.
Same conduct.
Yep.
Okay.
And what did your client allegedly do on both occasions?
So from the police report, I'll start with August 8th. The allegation or the prosecution version is that the complaining witness was at home. He had a friend there and they were smoking some weed. And my client allegedly comes over to the house demanding some property back out of the blue. The complaining witness says, "I don't have your shit, get out of here." Client allegedly gets mad, charges at him with a knife. They engage in some kind of fight, and then my client grabs a bungee cord from his pocket and begins to strangle the complaining witness. There's a neighbor who witnesses this whole thing and breaks it up, and the friend who's smoking weed on the porch is just kind of just standing there.
Wait, okay. So can we just go back? This is all happening on the porch. So it's outside in the open where anyone can see.
Not exactly on the porch. The complaining witness and the friend are smoking weed on the porch, and that's when my client rolls up on his bike, and the fight happens kind of on the sidewalk in front of the house.
I'm already loving. Your client rolls up on his bicycle and allegedly has a bungee cord that he just keeps in his pocket. Okay.
And a pocket knife.
So at this point, you have two other witnesses. You have
That's
the
correct.
complaining witness's friend, and you have a neighbor.
That's correct.
Got it.
Okay, and I'm sorry. So he rolls up and he threatens him, and he pulls out a bungee cord. What do you do with did he tie him up, or did I miss that? No, he didn't tie him up. He threatened to tie him up.
That's correct. No, the allegation, he stands behind him and then chokes him out with the cord.
Okay, and I think, Lauren, because I heard one of the first charges was burglary, right? Or is that in the second
That's
case?
the second
That's
one.
the second case.
Okay. The first case, this is the first case. And what were the charges for the first case again?
Aggravated stalking
Okay.
in violation of a personal protection order, domestic violence, third offense notice, and then felonious assault, to wit, a knife.
Okay. And what do you do with the knife?
Not the bungee cord.
The bungee cord becomes relevant later because they try to add charges at the preliminary examination.
Okay.
Oh, okay. So the charges for a knife then, the assault with the...
Holds it against his neck.
Okay. And all
So
this happens on the porch.
Because of money?
No, the client goes over to the house demanding his property back, like his TV
Property,
and
not
like
money.
yeah.
Because they broke up.
They broke up.
So this is the. Do you want to give this person a name, the complaining witness?
We can call him, the name becomes relevant, so we can call him Marty.
Okay. So Marty and your client. Do you want to give your client a name?
Let's call him Mr. P. I have my client's permission to talk about this case, but
Okay,
I don't
sure.
want to give the full name.
So Marty and Mr. P were in a dating relationship, and Marty and Mr. P broke up, and your client, Mr. P, went over to the house on his bicycle asking for a television back. I was going to load that right into the back of the bicycle. Yeah, I have that right so far.
That's right.
And when he rolls up, Marty is engaging in some herbal refreshment with a friend on the porch. And the situation escalates to Mr. P allegedly choking Marty with a bungee cord and standing behind Marty and holding a knife to his neck.
That's
and
right.
You said that there was also aggravated stalking because there was a TRO in place?
Yep.
Okay.
So they were dating for 10 years. It was my client who broke up with the complaining witness, and that becomes relevant later. But in 2022, the complaining witness had taken out a personal protection order against my client while they were still on and off again.
Did you have a copy of that TRO so you could see what the grounds were?
Yes, the PPO was included in the initial discovery, and it was 4 prior acts of violence, assaulting the complaining witness.
Okay, so that's a bad fact for you. Okay.
All right. So then that's the first incident. Now your client, does he just takes off after using the knife and the bungee cords on him? Does he take
Yep.
off?
He
on his
takes
bike?
off,
Okay.
rides off on his bike into the sunset, and the cops are called, but they don't get there till the next day.
The next day?
Yeah.
That's Detroit for you. You're lucky to just get the cops to respond at all.
There's no neighborhood police force? It's
No.
all...
This didn't happen at like 11:58 p.m. and you mean by the next day they got there at midnight?
Yeah.
It did happen late at night when the sun was down, but they didn't get there till like the next morning. Not at like 1 a.m. Like maybe like 10 a.m. the next day.
So the cops get there the next day, they take a report, and then what? That's it?
They take a report. Their interview with the complaining witness is caught on body camera. And I can tell you about what's on the body cam now or later.
I guess now, sure. Yeah.
So it's only a 10-minute clip, and the complaining witness comes out, talks to the two officers, and he says basically what I just told you. But he includes that the whole incident is caught on his Ring surveillance camera, and you should look into that.
Oh, I was
Police-
going to ask you if there was a ring. Okay.
Yeah. He also tells the police, which is caught on body cam footage, the knife that was used to assault me is in the house.
Okay.
But
How
the
did
police don't ask for it. They don't collect it and tap it in.
Where did the knife come from?
So if we're following the complaining witness's story, client must have had it with him when he rode up to the house. But for
But
some
then he
reason,
just left it? Did he leave the bungee cord?
no, he took that with him because no weapons were recovered.
And do the police in the video, do they respond, be like, oh yeah, we'll get that video, or oh yeah, let's go get that knife, or is there like even an acknowledgement that evidence was mentioned?
Absolutely not.
Okay.
They don't even
Protecting
acknowledge
and
it.
serving at the highest level
Yeah.
right there.
So what, if anything, do the police do next with respect to the first call?
So on body cam, the police officers are asking him, because they hear about this bungee cord choking, they ask him, hey, did you lose consciousness? And the complaining witness doesn't verbally respond, but he kind of just shrugs his shoulders.
Okay.
And that's the extent of the body cam.
Did they interview the neighbor who broke this up? Because I have lots of questions for the neighbor already. You said it happened late at night. The sun was already down.
On body cam footage, they do not ask for the friend's name. They do not ask for the neighbor's name. They do nothing.
And there's no interview statement by them as well, right? Were they
Correct.
they were there the next day, so it's like the friend and the neighbor could have been gone the
They were
next
gone.
day. Okay.
Right. But you would think if you had any interest in solving this case, you'd be like, hey, can I get that person's name?
Seems pretty basic.
All right. Anything else that the police may have done on this first case in that
No.
No. Okay.
Wait, I have a question. The stalking charge, is that just because of the violation of the order, or was there more to it than that?
The more comes out at the preliminary examination.
Right, but at this point, before the prelim, I don't know if the law's different in Michigan than it is here in California, what the penal code is, but you wouldn't get a stalking charge for one. If there was a protective order in place here, there's a charge for that, violating a court order, but it wouldn't be stalking. But you're saying your client was charged with aggravated stalking. So was there more in the report at this point before getting to the prelim
Or
that
could
would
I
explain the stalking charge?
or could I ask, like, what is stalking in Detroit? You know, like,
Yeah.
what is that?
So 1 second. I have the elements.
I mean, it sounds very threatening. And to me, it seems like it would be a repetitive type of behavior.
So it has to be more than one willful, separate, non-continuous acts of unconsented contact that cause the person to suffer emotional distress, that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, or harassed, and the complaining witness actually felt terrorized, frightened, intimidated, or harassed, and it has to be in violation of a court order, a personal protection order, or the individual made one or more credible threats against the complaining witness or their family members.
But it could be one threat. Then that was
Yes.
an or. So
Yeah.
they can get to the stalking because of your client. Your client said something, right? Like, give me the stuff, and they had the knife to the throat. So that could be the one threat.
Yep.
So that's how they got to stalking?
Yep.
Oh, that's bullshit.
Yeah.
Okay.
It only takes one act, or there has to be one prior act and then one act.
For
If there was
aggravated stalking?
if there was no protective order, then this wouldn't be a stalking, right?
That's correct. It wouldn't be aggravated stalking.
It would, okay, just be regular stalking.
Yes.
So one act can be stalking, two acts becomes aggravated. So it seems like you could have stalking on any alleged crime, right?
Wait, but he just said that it was or one threat of violence. So even though it was one act, it's still aggravated stalking.
If there is a personal protection order in place or a court order or stay away order.
Right. Okay. So the combination in this case of the fact that there was an order, you said it was put into place by Marty McFly before they broke up, and then your client allegedly made a threat on that day, even though it was just that one instance. That's how they got aggravated stalking.
Yes. And also remember that in the personal protection order, there were allegations that client had assaulted him in the past. So there were more than one, even before we even talk about the August 8th incident.
Yeah, but could they use those? If Marty used the prior acts to get the protective order, wouldn't for legally for it to be stalking, for them to say there was more than one incident, wouldn't it have to be incidents after the order was in place?
That's how you get to aggravated. So before it was just stalking. The personal
I see
protection
what
order
you're
getting put
saying.
in place, that's what makes it aggravated stalking, if that
see.
makes sense. Yeah.
Yes, got it.
All right, so then let's move on to the second incident, August 8th. First incident, August 5th. So 5th, 6th, 7th, 8th, 4 nights later. What happens?
Yeah.
Please say he rolled back up on his bicycle.
We don't know how he got there.
Debo style.
That's what I'm imagining, yeah. But client is also very frail and small and thin, so maybe not exactly Debo.
Debo, oh, okay.
Debo light, right?
Debo like.
So complaining witness is at his house again. He's by himself this time. And again, client rolls up unannounced, pushes in an air conditioner unit, climbs in through the window, damages the frame, and then while complaining witness is sleeping, starts wailing on him. And then client walks out the front door, complaining witness calls the police the next day. And this time, they don't even dispatch officers.
So there's a
I
phone.
just have so many questions.
So there's a phone call to the police.
Yeah.
What's
Like, how long later, though? You said the next day.
Let me look at the CAD notes. So he calls the police at 9 a.m., around 9 a.m. So he waits a whole night before calling the police, according to the CAD notes.
Can we just lay some groundwork here?
Yeah.
You said your client was tiny. How old are we talking?
He is mid to late 40s.
Okay, so this isn't not an old man, but this isn't a young person, and they're small. And what are we talking about with Marty? Is Marty around the same age and build?
Marty is in his early 30s.
Oh, a younger man. Okay, Mr. P.
you perked our interests a little bit there.
Yeah.
You got me interested.
So Marty is younger. Is he built larger? Is he also of small stature?
Not that bigger. I'd say they're similar height.
Roughly the same size.
Yeah,
And Marty lives alone?
he does. He inherited the house from his grandfather who passed away.
So this is a house in
Detroit.
no shared walls?
Nope, single
Okay.
family. It's not a duplex of any kind. It's just him in that house.
Okay. And so in case number 2, Mr. P arrives. Where is this air conditioning unit that
It's
he pushed
in his
allegedly?
bedroom. So it's like I don't know if you guys have this in California. It's like a window unit.
Yeah.
Yeah.
But this isn't like in a front window where the Ring camera might be in play again. Okay, so he goes around back to the bedroom and pushes this in. And does Marty say he wakes up to him there?
He says that he is woken by the punching of the face. That's when he wakes up.
So the air conditioning unit being pushed out of the wall onto the ground, presumably making noise, doesn't wake him up.
It's a very sound sleeper.
I mean, at its face, this story makes absolutely no sense. But
And
yes,
it's dark,
that's the story.
I presume, in his room.
Yes.
So how
Because
did
it's night and he's sleeping.
He said he for sure saw that it was Mr. P. He knew who it was, his attacker.
Yes, because after he gets hit in the face, he wakes up, and then they engage in some sort of struggle, and they've dated for 10 years, so identity's not really an issue in this case, and says, yeah, that's Mr. P who assaulted me.
Did he say that your client said anything?
At the exam and in his written statement, there is no mention of why the fight occurred. I get filled in through client
Okay.
when I
But
talk to my client.
From what you know, when you're getting this case, there's literally no information except that he rolls in through the window and beats him up and then just casually leaves. He's like, all right, I'm done.
Yep.
Were they
This
still
police.
sleeping together?
I can get into that now or later.
Later. Get into that later. Okay.
Mhm.
So then client runs out. What's the name for client we're going with?
Mr. P.
So Mr. P then leaves. Does he go back through the wall again? Or
Back to the front door.
he goes
Or
through
actually,
the front door. Through the.
I like the little.
Does he go through the? Yeah. Does he Superman out the wall? Or is he
he
just
busts through like the Kool-Aid man, yeah.
And then but then Marty doesn't call the police until the morning. And you said the police don't even respond. They just go and arrest Mr. P right away? Or how does that happen?
So After the call is made to 911, police are not dispatched to the house, and Mr. P isn't arrested until 4 months after these allegations allegedly occurred.
What does you heard a 911 call, right?
I don't have the 911 code calls because the incident occurred in August,
Yeah.
and he wasn't arrested and arraigned on this until January of 2024.
And what, they delete them?
According to them, and we have this fight with DPD and prosecutors all the time, there is a 90-day retention
No
period.
fucking way.
Yeah,
That is
but-
no way. No.
Calling bullshit.
No way.
There's
No.
literally statutes on point on this issue where they have to preserve that because it's evidence whenever there's an ongoing criminal investigation, but there's no remedy for us.
They dig that they dig up the oldest fucking 911 call. There's no fucking way.
When it's
That they
helpful to
delete
them,
it.
they dig it up, but when it's hurtful to them, they don't.
What is this? Is this like 7-Eleven? After 90 days of retention? Is it the same company that's doing security? What the fuck? Like,
I smell a trombetta motion.
Yeah.
all right. So, I mean, because I would love to hear that 911 call. Don't worry, units aren't on the way. The units will not be showing up. That is not the officers at your door. You know, we hear that all the time on the phone calls. Officers are approaching right now. That's them knocking on the door. You know, like they're like, no, we're just gonna go get him, Mr. P. We have his. You don't need to tell us his address, and then they don't even get him till 4 months later. So,
Okay, listen, I never want to be the one to defend the cops, but to be fair, by the time Marty called, there was actually no ongoing emergency, right? Marty waited hours long after Mr. P had Supermaned out the door before he called the police, right?
Hilariously, I looked up the police report again. He doesn't call 911. He calls the telephone crime reporting unit, which is a
The
non-emergency line.
non-emergency line.
Yeah.
I mean, it doesn't seem to me like Marty's really that concerned about anything.
was there? I mean, because now did Marty have injuries on his face? Were photographs taken? To
So
corroborate?
He
Did they do
goes.
any police work,
It's like-
Glenn?
So on August 31st, he goes down to the police station and gives a written statement and gives his account of both incidents.
2 or 3.
Yes. And when he talks about the August 13th Superman jumping through the window incident, he says that I was punched in the face, kicked, and I had bruising underneath my left eye. But there are no photographs. There are no medical records.
He didn't take any selfies.
Not for this case. There are selfies for a 2019 domestic violence conviction that my client was convicted of against Marty, which becomes relevant at trial and forms of 404B evidence, but no
Okay.
photographic evidence for this case.
Is your client a documented citizen?
He is. They're both citizens.
I'm just trying to think if there might be any reason for the complaining witness to be making up stories to harm your client.
There's a very good reason.
Okay.
All right.
All right.
So then what does that police report look like, though, with the August 8th incident, the Superman incident? Like, does it just like, we got a call and then we arrested someone months later? Like, how does that
It's
read?
13 pages, 6 pages of which are the information and charges. The police report paragraph is 3 sentences saying Marty called, made these allegations, cops not dispatched.
Cops not dispatched.
Yeah.
Okay, so then there's, after this phone call, is anything done on the case until Marty's arrested 4 months later? Or are we just jumping straight to the arrest of Marty?
Nothing else is done. No
Nothing-
investigation.
No one does shit. All right, so then 4 months later, how does Marty get arrested?
They have an arrest warrant for him and they go to his last known address. It's a SWAT style arrest for this stupid allegation. There are 6 officers, 3 officers are hanging back, and this is all on body cam, are hanging back with assault rifles pointed at the house. And there's an entry team with 2 officers wearing like SWAT-like vests, knock on the door, and the sweetest old lady comes out, which is my client's aunt, and says, "Oh, what are you guys here for?" And they ask for Mr. P, and Mr. P slowly walks outside and just surrenders.
Yeah, because there's fucking guns.
I would too.
So 4 months later, they wanted to make sure that the evidence was destroyed, that the 90 days had lapsed, and then they went and arrested him. Okay, all right. And does Mr. P give a statement to the police?
He does not. they don't
Right.
actually
Yeah,
even
Mr.
bother
P.
interrogating him. They don't ask him any questions.
Oh my god. Oh my god. Because the neighborhood defenders do such a good job of educating the public on asserting their rights to self-determination. They already know
Exactly.
that people aren't going to be talking because of the neighborhood defenders are on it. So
That's right.
I like that. All right. So then what happens next is Marty has a case filed and he's arraigned in court. Can you tell us about that?
So there's a different division of Wayne County who handles the arraignment. So I don't actually come into the case until after he's arraigned, but before the preliminary examination.
All right. Tell us about that when you meet Mr. P. What was that like?
So Mr. P is kind of quiet, reserved, and doesn't really have a lot to say until we start talking about the relationship dynamic. Then I don't know if you've had this experience with DV clients where they sort of just unload the full history of the relationship. But in this case, it was actually really helpful because it helped me understand their dynamic. So at the initial client interview, he goes into their dating background. He says they've been dating for 10 and a half years. It was Mr. P who had broken up with Marty around 2020 during COVID. And at that point, Mr. P had moved to Akron, Ohio. He was dating a new younger boyfriend in his 20s, but he didn't
he was.
officially break.
He likes the younger guy.
But he was not honest with both partners because he was dating both of them at the same time when he really should have just broken up with one of them.
Mr. P's a player.
Mr. Player. Mr. Player is what they call him.
Okay.
And they ran in the same circles because the gay community in Detroit is not that large. So
I don't imagine it's very large in Akron, Ohio either.
right? So Marty finds out that Mr. P is dating this new boyfriend, and that's the source of conflict, and that's the motivation, at least
A
to
lover
us.
scorned.
Yes.
That's crazy. So he knew. So Marty found out, but Marty was living in Detroit, found out that Mr. P, who's now living in Akron, Ohio, is dating a younger person, but still is with Marty at the same time?
Yeah, because
He
Mr. P
traveled on his
eventually
bicycle.
moves back.
Mr. P moves back. Okay.
Yeah. And Marty had actually gone to visit Mr. P in Ohio. So they were still seeing each other.
Damn, he had them in not just different area codes, but different states and still couldn't keep it straight. He's still.
Okay. All right. So, but that happened like 2 years ago or so, or 3 years ago, right? So
Yeah,
then
so the
why-
breakup happened in 2020, but in the interim period, they were dating each other, and this
They were
allegation.
still hooking up.
Yes.
up until the present, or up until the case was.
Up until
August
Miss Marty made these allegations, yeah.
So wait, did your client say that Marty wanted to be officially back together with him?
Yeah, so
There it is. So yeah, so they're still hooking up, but Mr. P was out playing and was not recommitting to Marty after the breakup. Mr. P was just keeping Marty as his booty call and his bench player, and Marty wanted to be called up to the big leagues.
That's
And
exactly right.
Mr. P said no, and
which was
now-
essentially our defense theory at trial.
yeah, there it is.
Yeah.
So
He
then
became the
Marty
side chick when he
says-
was the main chick.
Yeah, right. Okay.
Dude, how many cases not guilties do we get because of a side piece allegation? It's like
Because these boys, y'all just can't keep it in one place.
we gotta start appointing counsel right when people start dating. You
Yeah.
know, they need to know the legal ramifications of that first date. Okay, like you have a right to an attorney.
So Marty is a lover scorned. Marty is salty, wants Mr. P all to himself, and can't have it. So we're approaching this as Marty is making all of this up because Marty is salty. Yeah?
Yes. And that's basically the conversation that we had about the August 8th incident, the first set of charges, where client says that he was at the house with Marty, and he was getting ready to leave to go to work, and Marty got upset because he was
After
triggered.
hooking up.
Right.
Yep.
They were drinking, smoking all day and hooking up. And when he's getting ready to leave, the complaining witness says, "You're not going to work. You're going to go fuck that other guy."
Which was probably accurate. Let's just be real. Let's be fair to Marty. So did Mr. P confirm that there was a third person there?
No, according to Mr. P, it was just the two of them all day.
Okay.
So, all right. So Lauren just did a great job of laying out the theory, the defense for Mr. P. And Glenn, what do you do to get ready for his trial to present that defense?
I like to do a lot of pre-exam investigation because it just expands the facts that we're working with, We tried to talk to Marty. He was not having it. We tried to track down the neighbors, but in this neighborhood, people are very distrustful of police or investigators or really anybody trying to get into their business, so they didn't talk to us.
What about the Ring camera?
We tried to subpoena the Ring camera footage. Ring said, fuck you. We canvassed the neighborhood to see if there were any other Ring cameras who had an active membership where they would have stored their cameras and their footage. None of that existed. So all our investigation pretty much recovered nothing.
Did you go to the prosecutor with a discovery request to have them get their IO to provide the witness information?
Yes.
And that was met with negative results?
Yes.
Yeah, unsurprisingly.
Because, I mean, it sounds like this witness never existed.
Also, if they did, it doesn't sound like the police were super concerned with finding them. So.
No. I mean, they didn't even recover the weapon that was allegedly used, so they're not tracking down this witness.
So I must have missed that. There's no identifying information for the neighbor or the pot-smoking friend. There's no identifying, like, does it lives in that unit across the way, lives in this home over there. Okay. All right. So then anything else you do to get ready for the defense at this time? Any other defense work? All right.
We go into the preliminary examination.
Okay. And what are your goals at the prelim?
Wait. I just want to back up. You said that there were no pictures after he had been hit in the face, but there were no photographs after the first incident, too, right? Where he might have had marks on his neck from the bungee cord or the knife.
That's correct. And there was, I mean, luckily there was body cam footage of the police talking to Marty the day after it happened. And Marty's on body cam saying he choked me, look at my neck. And the officers lean in and you can get a glimpse of his neck and there are no injuries.
Okay, so you're going into prelim right now with nothing, really. I mean, there's just, the case is going to be your client's word against the complaining witness because there's no corroborating evidence of any kind.
That's right.
Wow. You know, it's almost like the police don't believe Marty, too, right? If they're just like haphazardly, they're not doing shit, really. They're not even, I mean, maybe they're just trying to let it go.
Yeah. Is it incompetence or did they have a gut feeling that Marty wasn't telling the truth? Hard to tell.
And since when does an alleged victim not telling the truth that's going to stop the cops from arresting somebody? So, okay, so then what are the goals at the preliminary hearing?
So I wanted to lock in his testimony because at this point, I at least know the statements on body cam footage are going to differ from his statements, his written statements that he provided August 31st. So I just wanted to see if he'd make a third inconsistent statement. I didn't go into the preliminary examination.
Wait, I'm sorry, you said he hand wrote a statement?
August 31st. That's when he went down to the precinct and provided a written statement for both cases.
And was that was different from the body cam?
That's right.
In what way?
The consciousness bit. When the officer asks him, did you lose consciousness on body cam? He sort of shrugs his shoulders and doesn't give a definitive answer. But in his written statement, he says, he choked me. I almost passed out. I was faint.
Hey, did your client say that between when the second incident was alleged to have occurred and when Marty went to the police station that anything happened? Like, did they have a fight or a confrontation about their dating relationship or anything?
No.
Okay. I was just wondering if there was an event that was a catalyst for him going down to the station to write this statement.
If I had to guess, I'd imagine the detective was like, fuck, I haven't done any work on this case. I should at least get a written statement from this guy.
Okay.
And so at the prelim, though, you just want to like lock in the complaining witness or alleged victim, see if they'll make a third statement, say something that's inconsistent with the other two statements. So that's all you're going to do is just questioning them. Mr. P's in custody, right?
He is not. In Wayne County, you'd be surprised at the number of clients who are out of custody.
All right, on. That's great. That's great. You know, people get really upset about that whole no bail, like the whole bail issue, and people, they're just letting all the criminals out of jail, Okay, great. And do you want to make get on your soapbox and argue for no, like people being out of custody pre-trial? You want to like say it's great or anything?
I am actually super interested to see if there are any long-term studies about recidivism or violating bonds when counties that have really liberal bond situations. At least for us, we're keeping the data, and we have the benefit of having a computer scientist turned lawyer who tracks all that information for us. So in about 10 years, hopefully we can use that to advocate.
Okay.
Good.
Just got to wait those 10 years.
Yeah.
Just come back to court, guys. Don't miss your court date, please. Okay. All right. So tell us about the preliminary hearing. How's that go?
So I didn't plan on impeaching Marty going into the prelim because I wanted to save it for trial. I know that's a strategy call sometimes we make. But another tidbit that my client shared with me during my client interview was that Marty is a party animal and his nickname is Party Marty.
Stop it. Hey, are we talking like meth party?
Not meth, but cocaine, alcohol,
Okay.
stimulants, poppers, but when he,
Ketamine.
yeah, it's all has some recreational allure.
Okay.
So when I saw the complainant was come in, he was all buttoned up, dressed nicely. He was presenting very well. That is not the image that I had in mind. So midway through the preliminary examination, I wanted to see if I could get Party Marty to come out, so I started impeaching him. But he kept his cool.
Did your client tell you that he could lose his cool, or was there something he said that was your client trying to tell you stuff that would make him lose his cool?
Some
Things like
button
that?
to push.
Yeah, like
We glossed over this fact. On the August 8th incident, my client told me that he was there all day. So at one point during the day, he went into the backyard to have a cigarette and he saw 2 used condoms with semen in them in the backyard. And so when Marty confronted Mr. P about leaving to go fuck his new boyfriend, he threw that back in Marty's face and said, "You're fucking guys too. What are these used condoms?"
Seriously, Marty, you can't be mad.
But I didn't want to bring that up at the preliminary examination because that gives my client all the motive in the world to, assault Marty for being angry that he's sleeping around as well. So I just left that.
it's also a misdemeanor battery. You threw definitely I mean, why would Mr.
That's a
P
gassing. If there was bodily fluids, that's
Just
a
throwing-
gassing.
That's definitely an offensive touching.
Yeah.
Dude, but that means Mr. P picked up dirty condoms on the ground and threw them. Dude, like, ugh.
Well, I mean, they've also been dating for like 10 years. So like,
And so, but you were not able to let him
whose
lose.
dirty condoms were they? Ew.
You weren't able to get Marty Party did not lose his cool, right?
he did not, no.
Okay, Glenn, I really respect the fact that you came on this show, said your goal of the prelim was to have him lose his cool, and I was not able to. Usually the lawyers on this show follow it up with, and I got him lose his cool or something like that. But I appreciate that much props. Like,
It's also a lot how it goes. We try stuff, right? Like we just got to try stuff. It
Yeah.
didn't really work, but
that's
we
the real
appreciate
story.
the effort. Yeah.
The real story of the public experience. You guys, the beyond the
Yeah.
wins. All right, and then what about was the judge okay? The prosecutor during the prelim, like, can you tell us about them?
So
What's the judge like?
the prosecutor's fine.
Okay.
The judge we're in front of is, I'm not going to say his name, but if you just look up the article I'm talking about, you can easily find him. He has a YouTube chat that goes on during all his hearings, and he calls it Blank Corner. He selects people in the YouTube chat to become moderators, and it's kind of like a cult following. And he got in trouble recently and was suspended because... I'm sorry, Lauren, you're making a face.
You're telling me that he like live streams his courtroom while he's on the bench
That's right,
and
yeah.
engages in a chat with the people who are tuning in
That's right. And
while
this
he's
was...
presiding over matters.
Yep,
And they can chat. They
So-
can chat back at him.
This
yes.
is just
This is
okay
interactive.
in Michigan.
This is why he also got in trouble. He had invited some grade school kids, elementary students, to observe court. One of the kids had fallen asleep, and instead of being compassionate and sympathetic with this sleepy child, he holds this kid in contempt, threatens to put him in Wayne County Greens.
A fourth
And then-
grader?
Elementary student, I don't know exactly how old she is, but she is in elementary school, and tells her classmates, "Please raise your hand if you would like to see your classmate thrown in jail for disrespecting the court."
What the fuck?
Yeah.
Wait, you knew all this before the prelim?
This happened a couple months after the prelim. This particular judge has been problematic. So he's a former Wayne County prosecutor, so he's very prosecutor friendly.
So then was the prelim then was televised on YouTube then, presumably?
Yeah. This prelim, all his prelims are televised on YouTube, and they're still up, I think. Unless
This
36
is crazy.
It is crazy.
And so then your prelim, this particular prelim we're talking about, was on YouTube then.
I believe so.
Okay. Other than, I mean, did anything happen during your preliminary hearing with respect to this judge or how things went down, or was it just a normal prelim?
It was a normal prelim, but the prosecutor tried to add assault with intent to do great bodily harm by suffocation or strangulation for the bungee cord. But because of the several impeachments that happened throughout the preliminary examination, the judge said, I don't find those allegations credible, so I'm just binding or holding him to answer in California terms as charged.
Did Marty testify inconsistently again, or was his testimony consistent with his written statement?
His testimony at preliminary examination got worse. The facts and the story grew.
Always does.
Yeah.
Every time they tell it, there's suddenly more dramatic and dangerous.
I think one thing that I remember specifically is that regarding the weapon that was used, in his written statement, it was a pocket knife. But at the preliminary examination on direct from the prosecutor's questioning, he says it was a sword knife that was, and he holds up his fingers, 12 inches, like the ones they use in action movies.
Not even a kitchen knife, a sword knife?
Action movies?
That was his testimony.
Where did that come from? This motherfucker rode up on his bicycle. Wait, he had like a sheath, he pulled it out of.
A machete?
Where did that come from?
And he also testified that he definitely lost consciousness. That was the big thing too.
And then how was your client during the preliminary hearing?
I always advise my clients when they go into the prelim, because the judges are so difficult, to just keep a poker face and don't react.
All right. Okay, so then you said you impeached him several times. So what would you impeach Marty with?
When he testified on direct that he definitely lost consciousness, I used the written statement and the body cam to impeach him that you didn't tell that to the officers. It's not included in your written statement. And then I impeached him with his written statement about the sword knife versus pocket knife.
I mean,
that's cool. I mean, that's good that the judge didn't add charges, you know? So it seems like no one really finds Marty too credible so far. The cops didn't, the judge doesn't. But he's held the answer to the charges, so now we're going to head over to the trial phase.
Were your charges wobblers? Do you make a motion to reduce them to misdemeanors?
No.
Is that available to you? No. Okay.
Okay, so now we're held over to answer for trial now. Anything you're doing to get ready for trial?
I filed a motion to quash. I think in California it's called the 995.
Okay,
is that
so
right?
So you're saying that they didn't present enough evidence to substantiate the charges that the prelim, your client should not have been held to answer the trial.
And they laughed at you as they
That's
laughed
right.
at us. Yeah.
It's the same here.
Did you think
they
you were
said
going to
give
win?
it to the jury.
No, absolutely not. I mean, I filed the just cause. But sometimes you win these Hail Mary motions. Why close the door on yourself?
You miss every shot you don't.
Exactly.
Okay, so did you do any other work? Anything else? Investigation, last-ditch effort to talk to witnesses, or actually you got a sense of Marty at the prelim. Did you think like, oh, I can get this guy at trial? He's not credible. Like, what were you?
I mean, my client and I felt pretty good going into trial because we had 3 different versions of his story now, and we have a strong motive for Marty to lie.
So I have a question that David might want us to wait till we get to this, but were you prepared for the prior acts then, to defend against the prior acts as well?
Yeah. So before trial, we have a final conference and a motion hearing, and the prosecutor filed a 404B notice to introduce the 2019 misdemeanor domestic violence conviction that my client was convicted of against
You
Marty.
didn't tell us there was a conviction.
Yeah. Sorry, I might have glossed over that, but it was a conviction. He pled guilty to a misdemeanor.
This is also the PD way. We bury those bad facts.
Yeah.
we don't lead with that. So there weren't just prior unreported acts that were referenced when Marty got a protective order. There was an actual conviction for misdemeanor domestic battery against that your client had, Mr. P had. Was it also with Marty?
Yep.
Dear. Okay. All right.
And so there was a hearing to introduce that as evidence. What was the hearing you had with the judge before the trial with respect to the prior conviction?
So in Wayne County, we do all the motions in limine the day of trial, which is super annoying because sometimes it actually affects your theory of the defense.
Mm-hmm.
But we held the motions in limine. I filed the motion in opposition to the 4B evidence. My request was denied.
The 404B evidence being the prior domestic violence misdemeanor conviction.
Yeah, I also filed a motion in limine to exclude the photographic evidence that came with the 2019 conviction because in that case, there were selfies that Marty had taken and the injuries were pretty bad. There was severe bleeding, bruising, and cuts underneath both eyes. The pictures made the misdemeanor seem much, much worse.
Did you win that?
So his ruling was kind of weird. He ruled, my argument to exclude the photos was that there's already a conviction. You don't need the photos because typically at a pre-trial or pre-conviction posture, prosecutors use photos to corroborate the allegations. But because there was a conviction, we don't need those photos. The judge ruled that I'm not going to allow a certified copy of the conviction to come in. I'm just going to allow Marty to testify about the 2019 allegations and let the prosecutors use the photo.
Really? So then
Yeah.
that seems kind of silly because now that means you can contest that factual scenario, really, because there's no conviction to back it up. But can we just explain the law when it comes to prior acts of domestic violence in domestic violence cases, right? And, as Detroit or Michigan, I'm sure is probably similar. It's pretty uniform, it seems like, across the United States that you can bring in a prior bad act of domestic violence to prove a current act of domestic violence, right?
Which is an exception. Normally, we don't allow prior bad acts.
Yeah, normally you can't do that. Normally you can't bring in prior bad acts to prove the current bad act. But if it's domestic violence, you can. So now you're having a hearing to see whether or not it's okay to do that. In this case, the judge said, yes, you can bring in evidence of the act, which would be through Marty, but you can't bring in the criminal conviction itself. Okay.
I think the requirements are pretty similar. It's subject to 403. It can't be too prejudicial. It has to happen within 10 years. Yeah. There's an analysis as to whether or not the conduct is kind of similar or not similar.
Okay. All right. Any other motions in limine? You said you wanted to exclude the picture from the 2019 conviction. Okay. Any other motions in limine?
Nope.
Wait.
Okay.
Are we in front of the same judge who did the prelim?
No. So that was a district court judge, and after we get bound over held to answer, we go to circuit court, and we get blind drawn or assigned to a trial courtroom. The first judge that we get assigned to is a judge that I've tried cases in front of. She's a former prosecutor, but really good on the law, and will actually grant motions. Yeah. On the morning of trial, she's doing a homicide, so we get spun out to a different judge, which is not as good of a judge.
I hate when that happens.
Just to give you a taste of what kind of person this judge is, he's an Irish Catholic guy. He's an old curmudgeon. He's kind of retired, who just is a visiting judge to fill vacancies.
This is the judge you're in front of now.
Yes.
Okay. 402 seemed kind of normal. So far, so good. Right?
Yep.
So I guess we're going to talk about the trial now. We're going to do with voir dire. Is there anything that we missed before we talk about the jury trial that we forgot? Maybe there's just a question we asked the right question. Was there anything you want to share up until now?
No, I think we covered everything.
Okay. All right. And then is Mr. P excited for trial? There was no pretrial negotiations?
No, the only offer that they came at us with was 6 to 20. And yes, years in prison.
So 20 years for this?
Because the statutory maximum, the top charge was home invasion first degree.
Okay.
And Mr. P said that the only offer that he would accept was a non-custodial offer, which
he would have
probation versus 6 years. Yeah.
Mm-hmm.
We were far apart.
Yeah.
All right. So let's talk about jury selection then. Tell us about what was your voir dire like? Did you have a certain strategy that you go with or anything particular in this particular case? Like where you're focused on?
So I do the Colorado method of deselection. So I try to identify the bad jurors, and I try to pre-try my case as much as possible during jury selection. So there were 4 main topics that I wanted to hit. Number 1, I wanted male jurors who had like an unsophisticated or problematic view on gay relationships.
Next.
The reason I wanted that is because one of my coworkers pointed out that it would be good to have straight males who don't believe domestic violence can occur between 2 males and deviate between gay couples.
I see it.
Working each other.
I'm not judging. It's just a fact. You want bigots. Next.
Yeah.
You want some Joe Rogan listeners.
That's right.
Yeah.
People who I wouldn't want to hang out with.
Right, yeah.
Yeah.
The real alpha male types who are making their little TikToks about, how to be more alpha male.
Yeah. We voir dired on domestic violence. We got rid of a lot of jurors because it's surprising how much domestic violence people experience just in day-to-day life. We got rid of a couple people who were victims of aggravated stalking for 4 cause challenges.
You could say thank and excuse. You don't have to say got rid of,
Yeah.
We totally tossed to the curb. We battered those battered DV victims out of the courtroom.
No, David, Gleno's trials are a little bit like Squid Games. Like, if you're not making the jury, he pushes a button and you're done. He got rid of you. Did you voir dire on relationships other than the gay stuff, like for cheating? Did you try and weed out the other scorned lovers?
I love that you asked that because that was a whole area of voir dire, and I got a really great answer, which is not what I was expecting. I asked if anybody here has been through a messy breakup where they were a victim of retaliation.
Spill the tea.
Juror number 1 is a big burly white dude, and he says, yeah, my long-term girlfriend broke up with me, and she's just dragged my name. After the breakup, I got hit up by my close friends, calling me a terrible person. How could I do this to her? So that juror was right on brand and was right on board.
Would you like to be our foreperson?
And they didn't kick him for some reason. He made it onto the jury. Yeah.
Well, is there any other actions or particular interactions?
Hang on.
Go ahead.
That's a good question. So we know what your strategy is, right? That they're still hooking up. We know what your defense is going to be. But you said that Marty didn't give you any statements. So did you have any indication that Marty had told the police or the prosecutor that they were still having an on-again relationship, and anything that might have given the prosecutor a heads up to what your defense was going to be?
So I asked all those questions at preliminary examination, but he denied all of them. I said, you were still dating. You knew about Darian. You would text client. You were trying to get back together with him. You were hooking up. And he said, no. So our theory, I think, if you read the transcript, was that pretty out there.
Okay. So the prosecutor should have known and should have gotten rid of that juror, but didn't catch it or wasn't quick
That's
enough.
right.
Any other interesting interactions with jurors while you did voir dire?
There was one funny moment when the prosecutor, in our jurisdiction, prosecutor's voir dire is heavily food-centric for some reason.
Oh, the chocolate chip cookie with the crumbs and circumstantial evidence hypo they like to do?
Yeah. If there was a muffin on your kitchen counter and there's a bite out of the muffin and your kid has crumbs all over his mouth,
God, it's
who's
gone
the most
national.
likely?
It's
And
like
then they
in the
expanded.
prosecutor playbook.
And then they expanded to beyond a reasonable doubt. If I told you an alien could have come and zapped the muffin, would you think that's reasonable?
No, but the dog, I'm just saying. An alien, probably not.
So that was. Go ahead.
On the food topic one, they also use a peanut butter sandwich analogy to talk about elements of a crime. And so she opens the question up to the jurors, says, ma'am, what do you like to cook? And the juror says, Persian food. And she says, okay, let's talk about peanut butter sandwiches. And all the jurors are like, what?
Smooth. Nice transition.
But that's basically how well her voir dire went. She got nothing out of them.
And just to get to know the prosecutor, have you worked with this prosecutor before?
She was fairly new.
Okay.
I think she had just started about a year ago.
Did the prosecutor have a certain attitude towards the case or confidence that was sort of that you noticed?
She is a true believer domestic violence prosecutor, where she believes her victims and our clients are evil, which explained the 6 to 20 offer.
Okay. And did that come across? But just during the voir dire, though, she just did all the food stuff for them to like her, right?
Yep.
Yeah. And
it didn't work.
Does the prosecutor go first in voir dire, or do you go first in voir dire?
They go first.
Oh gosh, I wish they did that here. We have to go first in ours. So, and then we, as defense attorneys, we always have the most difficult part to explain, the burden of proof and proof beyond a reasonable doubt, and the right against self-incrimination, and all these things before we can even get to the theory of our case, and all these stuff. And then the prosecutor just gets to follow us to be like, "Hey, look at the mouse and the cookies and all the things." No, and they always get to have a more lighthearted experience with the jurors. It's a shame they're just not very personable, but
it's so robotic. I've never seen a prosecutor voir dire land very well.
I've seen there twice in my career. Twice I've seen a good prosecutor voir dire, or maybe just one that didn't suck. But it can happen.
It's a low bar.
Yeah. Okay, so let's move on then to the opening statements. How did that go?
So my theory of defense was that Marty was angry and vengeful after a messy breakup, and he's making these false allegations to get revenge on Mr. P. And I have a pretty strict formula, not formula, but I lay out my openings pretty much the same in every case. It's theme theory, defense story, look for these things, and you're going to have more questions than answers, not guilty.
Solid. The more questions than answers is a classic.
And the prosecutor's opening statement?
Pretty expositional. For my opening, I did, if I can find an alliterative triplet that matches my theme, I try to use it. So in this case, it was revenge, rejection, retaliation to like frame my theory.
Ow.
They were in a dating relationship. He got screwed over because he was dating this younger guy and cheated on, and he's making these allegations as revenge. That was like my framing device.
Dude, it's almost as if you had Eminem write it for you, you know, like that was beautiful.
Exactly.
That was
I
beautiful.
wrote it on 8 Mile for inspiration.
Okay, good. So both incidents, is August 5th, August 8th, are all into one criminal information.
Yep.
So both incidences are being tried. And so let's talk about the prosecutor's case. They have the burden of proof, and how do they go about it?
They put on the responding cop first.
Oh, to the first incident.
The August 8th incident.
Okay.
And I get what she was trying to do. She was trying to steal my thunder by asking all the questions that I would have asked about lack of investigation. And she goes through that. And at the end, the police officer says this for the first time. He says, actually, I did canvass the neighborhood for witnesses, but it's just not caught on body cam.
Or documented in a report, or
Right.
any way, otherwise notated.
I mean, the prosecutor probably talked with the officer before they testified.
What was the point of the office testimony?
It didn't really establish anything other than the fact that they talked to this complaining witness. He made these allegations. If anything, that officer was hurtful to their case.
So then did you get to cross-examine at that moment? Or of course you did. So tell us about your cross-examination.
I went through the litany of lack of investigation. You didn't track down this eyewitness. You didn't track down the friend. You didn't recover the weapon. You didn't look to see if there was ring surveillance camera. You said that you went to go canvass the neighborhood, but it's not notated in your report. It's not caught in your body cam footage. Actually, your body cam policy says that if you're conducting an investigation, you should leave it on, which you didn't do.
So you made the officer look terrible. But
Yeah.
you got out what was necessary, too. It sounds like the prosecutor did in front of the jury, like that there had allegedly been a ring video,
Mm-hmm.
and none of this was available to them.
No, and I love when cops do this, the responding officers. They say, it's not my job. It's the detective's job. And so when he says that on cross, I say, oh, this detective sitting right here at counsel table?
The IO.
Yeah, and he's like,
You're
yeah,
all
it's her job.
shit. You're all shit at this.
Did you bring out the lack of choke marks on the neck? Or they looked at that? Did you show did you show the body worn video of that as well?
The prosecutor admitted the body cam footage. So I just touched on that in closing. So
Wow.
I love it when they do your job for you.
Right.
You just get to sit there and look at the jury like, I don't really have any questions.
yeah.
That has got to be the worst opening to a trial I've ever heard of. I can't imagine what that was for. Usually, because sometimes I think they'll put up the cop first. If they don't think their alleged victim is credible, they might try to bolster it with like showing there was this investigation done and all these things are done. Just that way people can start buying into it early and then may believe the bullshit later. But it's kind of tough to believe this bullshit if this cop can't even deliver anything. So off to a good start. All right, who testifies? Next pertinent witness.
It's the complaining witness next, and the case just gets worse for them.
Go, Marty McFly. Let's go. Take us back to the day in question.
So Marty starts testifying, and he talks about the August 8th incident, and he goes through and says, I was assaulted. Mr. P came up rolling on his bike, and he was carrying around this 12-inch sword knife. And he talks about the bungee cord and says, he was choking me, but I did not lose consciousness. And the prosecutor impeaches her own witness. Because for her, it's better if he lost consciousness. So impeaches Marty with the exam transcript and the written statement. Yeah. That's right. I mean, if we're trying to be charitable, maybe he like reviewed his written statement or looked at the body cam footage and like, I gotta be consistent with one version. But at this point, like you pointed out, there were 3 different versions and they were all diametrically opposed. So no matter what he said, it would have contradicted something. I'd agree. And then the next thing he talked about was the August 13th incident when he testifies at trial that Mr. P came into the house, pushed in the AC unit, and punched me with brass knuckles, and I was bleeding profusely from my face.
Brass knuckles now.
Yeah. Yeah. I mean, it's hard to keep your story straight when there are so many lies. Yeah.
Did the prosecutor impeach him?
Not this time, but there's also a funny
okay.
thing that happened. I impeach him with this written statement, which he says, I was punched and kicked and there's bruising under my left eye. After all my cross-examination is over, the prosecutor gets up on redirect and tries to rehabilitate the impeachment and approaches Marty and says, didn't you include that you were punched with brass knuckles and you were bleeding from your face in your written statement? And Marty reviews the written statement that's in front of him. And he says, yeah, you're right, I did.
Wait, did he?
No. So
It's
I was also equally confused because the written statement definitely does not include that. It's the same written statement that's always been in discovery. So when the prosecutor walks away from the witness stand, I gently tap her and say, I'm about to point this very embarrassing fact out for you, but it does not include that. Do you want to bring it up or I will bring it up? So when the prosecutor slinks back to the witness stand and impeaches now the witness for the second time, your written statement doesn't actually include that you were punched with brass knuckles and you're bleeding from the face. And he says, yes.
man. Okay,
Yeah.
so
And at that point, there are multiple jurors laughing. Juror number one,
Yeah.
the guy, who is on board with our theory of defense, is like gesticulating and throwing his hands up in the air. It's like, what? Yes, absolutely should have kicked. Yes.
So, Glenn, when the prosecutor first said you did include the brass knuckles in your written statement, and the witness said yes, did the prosecutor say nothing further, no further questions, and then walk back to the table? And then that's when. And then you.
And I was looking at the jury this whole time. They understood what was happening.
So then-
because they were laughing.
So then, did the prosecutor then say, "One more question, Judge," or may I reopen, or how did that happen? Like, what? How did that happen?
There's a weird like verbal tick that we say in Wayne County. We say court's indulgence. I don't know if that's a thing in California.
Though I like that indulgence. Sounds very decadent.
So she says that and says, I actually have a couple more questions, Judge. Can I continue asking questions? And then that's when she points out, you actually don't say that in your written statement at all.
Wow. Right. You kind of. Yeah.
But also at the same time, pocket knife versus 12-inch action movie sword knife. Lost consciousness, not lost consciousness. And then you have the witness whose name that he can't remember, even though they're friends. And then you have the rings. You're faded. And then they have the ring surveillance footage, which he explicitly tells the police about, which doesn't exist or he can't produce. So at that point, he has no credibility whatsoever. So I don't really care who impeaches him. I did. He said he doesn't remember, which is a big point that I made in closing.
So then, did you, after the prosecutor corrected herself with Marty, what did you cross on? Just did you have any?
I had no recross. No.
That's okay. This sounds like a pretty easy trial, pretty quick too. I would say. Is this just all happening in one morning?
This was 2 days.
2 days of nothing? Was there 2 days of what? There's nothing that happened. There's no police work to testify. There's no injury. There's of what? There's no evidence to present. How is this 2 days?
I guess really 1.5 days, because the first day was just voir dire, and then we opened, and then we went on to the next day.
So just okay. So the testimony is 1 day. This is just 1 day. Okay.
Yep.
That's what I mean. Okay. Yeah.
I also should have mentioned before trial, we approached the conversation of client testifying or not testifying, and we had prepped a mock cross-examination, and it went horribly. Yeah. They were coming in regardless. No.
Okay. Any other stories with respect to with Marty? Anything else happened during Marty's testimony that you want to talk about?
Not during Marty's testimony.
Okay. All right. So So what was the next pertinent piece of evidence that the prosecutor put up?
So the prosecutor endorsed 4 witnesses for trial. And in Michigan, there's something called endorsed versus non-endorsed. And if an endorsed witness doesn't show up, then defense gets an adverse witness instruction. So on day 2 of trial, she was having witness problems because 2 of the officers did not show. Yep. Yep. Yes. That their testimony would have been helpful to the defense and hurtful to the prosecutor, unless the prosecutors can establish that they did due diligence in securing the witness's presence.
Who decides if someone's endorsed or not endorsed? Who makes
The
that
prosecutor.
call? Really? Do you get to argue for or against it?
No.
So the prosecutor is.
Yes.
And the prosecutor is ethically supposed to go through the evidence and see who may have favorable defense and then make them an endorsement. Just like they're supposed to go through the evidence and turn over anything that proves that someone is innocent or cast doubt on the case. So they have these obligations. Some prosecutors make them, actually go through with them. Some aren't as diligent.
I think it's really great because, sometimes the witness list initially are 30 people long. Yeah. Right.
Yeah. The defense witness list is usually just someone with the same last name as your client, It's just mama. Okay.
Yeah. Two. So half of her witnesses. So she came to me in Italy, and I tried to leverage her witness problems in my favor. I said I would stipulate to removing them from the witness list if you agree not to introduce the photos from the 2019 misdemeanor conviction.
Nice. Okay.
She agreed. She said, if you allow me to unendorse my witnesses, I will not use the photos.
Great.
And just use, yeah.
Oh, yeah.
No.
That's
Yeah.
That's a great move. I love that because you don't need there's already enough adverse things happening for the prosecutor during this trial. What's just it doesn't. The only thing that could sway them is if they see some fucked up photos, maybe.
Yeah.
So
that was the big concern. Yeah.
Yeah, that was your only concern. Well played. Well. kept it cool, you know, and also because maybe you helped her out too when you said, "Hey, you might want to fix this up." The written statement doesn't say that, so you know, good job, Glenn. Wow, you get more with honey or something like that, you know, like or okay, a lot of vinegar PDs out there, a lot of PDs who love vinegar. I'll tell you what, I did have vinegar on my turkey sandwich today. I'm not gonna lie. I'm fucking vinegar, fucking PD. I'll fucking take the prosecutor's nose and rub it in that pile of shit that they fucking present in court. No problem, but not Glenn. I can learn something from today.
Yeah. Yeah.
Yeah. I know. Okay. So that's the art of the deal. Take notes, President. All right. So what happens next in trial?
So we're closing up. We're approaching the end of the prosecutor's case.
Okay.
I forgot to mention this. Before the trial started, my client is on a GPS tether. And I asked my client and the tether unit to either deactivate the tether or turn off the volume, because sometimes when you're sitting through a trial and the battery's getting low, it starts beeping. Because it would be prejudicial, just like the same way we protect custody status. And so I brought this up to the court. I said, this might be an issue, just so the court is aware, so we can put some procedures in place. As Marty's testimony is wrapping up, the fucking tether starts going off, just like I advised the court would. And the court clerk who's running like point on all things in the courtroom is kind of new, English second language, and I have co-counsel at table. As soon as she hears the first beep, she goes up to the court clerk, lets her know what's happening, and the court clerk just sort of looks at my co-counsel and doesn't know what to do. And so while the tether's beeping, the judge has the brilliant idea of saying, "Oh, Mr. O, is your computer beeping? Let's take a break so you can take care of that."
Okay.
So when we break, that's when the conversation about the unendorsed witnesses and the stipulation happens.
Okay. Wow.
Yeah.
And a solid to the judge for cleaning that up. Now, wait, before the trial started, you said, "Hey, judge, this could be," and then was there something you wanted to do? Like
I wanted
turn it
him
off?
to remove the GPS tether
And the
to
judge
just get
said-
rid of the problem.
And the
Yeah.
judge
He
said no.
Yeah.
Right.
Yeah.
Yeah, I guess we're just trying to have a fair trial, Judge. You know, we're just trying to, you know. All right, so that's great that's how that went down. Anything else happened during the people's case? Any other witnesses that worth talking about, or just no? Period.
That was the whole case. 2 witnesses. Yep.
Yeah. All right, so then motion to dismiss.
Denied.
I know, right? No,
Yeah.
Judge is like, no, I think there's some credible evidence here that could go to the jury. There's enough evidence to go to the jury here, enough credible evidence. Yeah. Okay, so then now do the people rest at the end of the day? So you have all night to think about if you're going to put on a case, if your client's going to testify?
So it was only a 1.5 day trial. We voir dired and opened the first half day, and then the second day was a full day. Mm-hmm. So after the prosecutor rested, I made my pro forma halftime motion, put it on the record that my client's not testifying, and then we went straight into closing arguments.
Okay. And then what was the conversation with your client like for him not to testify? Because you said you guys did a practice run through and it wasn't so good.
It went awful. He started volunteering information that was absolutely terrible for our case, and it wasn't even like a blistering cross-examination. So he was not testifying, and we wanted to call his boyfriend to establish the fact that there was a dating relationship and that Marty, his new boyfriend, the younger boyfriend. But he didn't want to testify either because Mr. P and his new younger boyfriend were having some relationship problems.
So, you know,
I'm not going to say yes or no. Yeah.
Glenn. All right. Hey.
Yeah.
There you go. Yeah,
Yeah.
That's great. Ken's always keeping it real. I appreciate that, Glenn. All right, so defense rests. Now it's time for closing arguments. So tell us about your closing argument.
I just had so much to work with. I have actually stolen a lot from this podcast. I use the chart. I talk about the 3 pillars.
Do you mention another not guilty to the jury?
Yes. I name you specifically.
Do you say
who I've never met?
Thank you. I appreciate that.
But it's a pretty standard closing. You talk about the escalating burdens, how if they want to. The specific example I use is lawsuits between mega corporations for billions of dollars. It's this standard. If they want to rip your kids away and tear apart families, it's this standard. Yeah. Yeah. And then I mean, so much of this job is just plagiarism. I also stole a line from Blaise Kearney, who's also on your podcast, where he likes to quote Sandra J. O'Connor from a case called Victor's v. Nebraska, where they define reasonable doubt as a kind of doubt that makes you pause or hesitate in an important or grave decision in life. So I use that to segue into the skydiving analogy.
Yeah.
So the skydiving analogy is, imagine you're 10,000 feet up in the air and the flight instructor opens up the door to the plane and the cold air is rushing in your face, and you turn around, you look at your parachute, you're having some concerns because you're about to engage in some risky behavior. So you want to ask the flight instructor some questions, and you look at the flight instructor and it's Marty who packed your chute. And then I use the fact-specific analogies, like Marty tells you that he has footage of him packing the parachute, but he doesn't know where that footage is. He says he packed the parachute with this particular equipment, but then he changes what his story is. And also, that gives you some concern. So you turn to the flight instructor's supervisor who's supposed to check Marty's work. And they say, I took Marty at his word. I didn't do any independent investigation to verify that his story is true. That's the cop. If you wouldn't trust your life in Marty's hands, then don't trust Mr. P's.
Wow.
Yeah. It works so well when there is an inconsistent. Yeah. Yeah. And when I was delivering that line in closing, there were 2 jurors that I was making contact with, and they were shaking their head and laughing. I was like, okay, this case is fucking done.
God. Yeah. Yeah.
Yeah.
And how did the prosecutor's closing argument go?
I think this is also a universal experience. When they feel like the case is slipping away from them, they start getting angrier and yelling at the jury. She started doing a lot of that.
Yeah.
Yeah.
I do in stand-up comedy when I feel like I'm bombing on stage. I start cussing more. It's just natural, right? It's just yeah.
The desperation is just like
it's like yeah. You just start, like you're just losing.
Yeah.
All right. So then, how long were the jurors out for in this case?
They were out for about 20 minutes, but before they even started
Oh, wow. Okay.
Before they even started deliberating, the judge started dropping hints like he's not very good at concealing his feelings about the case. He told me and my client to not go very far because he doesn't think this deliberation is going to take very long.
Okay. Okay.
But the reason I don't feel good is because while the final instructions are being read, apparently behind us, the complaining witness has his whole family in the pews, and my client has his friends and family in the courtroom. And apparently there were some nasty exchanges or nasty words, so the deputies had to get involved and separate them. So when the jurors come back with a verdict, there were 10 deputies in the courtroom. Yeah. Right. But I didn't know that because yeah. But it was jarring for me because I didn't know why the deputies were there because they never told me that this fight was happening in the background.
Ah, okay. So then so 20 minutes later you come in, you're feeling good, but then you see all these deputies, but then the jurors come out, and then are they like happy and jovial?
Yeah. He wasn't actually. It was juror number 10, who was a fourth person.
Did Mr. P say anything after the closing arguments and you guys were waiting? Did he talk to you? Did you guys talk and he say like he felt good or anything like that?
He was pretty stoic throughout the trial. What also was happening, which, because I was just focused on the jury and the witnesses throughout the entire trial, I found out after from the jurors when we talked to them that my client was nodding in and out of sleep throughout the trial.
Wait. So he was sleeping? Yeah. Wasn't even worried.
So unbelievable.
Yeah. There's no way that guy's Superman through the air conditioning vent. Okay, so the jurors come back, they read the verdicts, not guilty on 6 charges, was it? Or something like
All
that?
6 charges,
All
yeah.
6 charges. All right. Did your client react?
He was happy. We hugged, we shook hands. But yeah,
Okay.
felt really good.
No, you talked to the jurors afterwards. They said Mr. P was sleeping. Anything else?
8 of them stayed behind. They were very eager to talk about the case. 2 of the jurors said that they had decided it was a not guilty after opening statements, which you're not supposed to do.
But that's why they're important. That's why it's important. That's why you do it.
They love the burden of proof chart.
The dumbest chart ever. I mean, it's effective. It's effective chart, but there's nothing special about it at all.
Yeah.
Sometimes it's a pyramid or, might as well be a food chart. I don't know. Okay.
The juror who said that she loves Persian food really wanted to ask me about the peanut butter sandwich analogy because she was so confused. It really stuck with her. She's like, do you remember that moment in voir dire when I said I like cooking Persian food? And then she pivoted to peanut butter sandwich. What was that about?
Yeah.
Yeah. No, you shouldn't. They brought this case. They shouldn't have charged it.
Yeah. Okay, so any other interesting things that the juror said?
The 4th person was an older black guy who was very machismo, and he took our theory and ran with it. He said, if there was some domestic violence, you think your client, a man's just going to sit there and take it? Or actually vice versa. If Marty is a man, he's just going to sit there and take it? He would have fought back. Yeah. So yeah.
Nice. Okay, great. Well, this is did anything else about this case that we might have missed that you want to share? A temporary restraining order in place or anything like that?
No.
Okay, good.
To my knowledge, Marty and Mr. P are not dating,
Yeah.
but Mr. P and his new boyfriend, Darian, the younger one, are still dating. It's a safe bet.
Well, once the not guilties were declared, the court protective order throughout the case was no longer there, right? That was terminated.
The no contact order was terminated, but I don't exactly remember when.
All right, Glenn, thanks for reaching out to the podcast and sharing your story with us. It was fun hanging out. Kind of easy trial, Not to say that their trials are easy. I mean, well, that's great though, Glenn. So, okay, Glenn. So we're going to wrap it up now. We're going to end it with ask you this last question, which we ask all our guests. You're a public defender over at Detroit, the Neighborhood Defense Team. I'm sorry, Neighborhood Defense Services. Is that right? Did I say that?
Neighborhood Defender Service of Detroit.
Neighborhood Defender Service of Detroit. And so then.
Yep.
Okay, great. So then tell the A&G audience why you became a public defender.
So the short answer is my parents are first-generation immigrants from Korea. They came over here with basically nothing. They couldn't speak English, not a lot of money. They settled in Los Angeles, working a lot of blue-collar jobs. And so when I was growing up, I have friends, families who have a lot of contact with the criminal legal system. But when I was in middle school, my parents had some class mobility and moved up to sort of middle-class jobs and moved us to a better school district. So from a young age, I got to see how my friends growing up were treated and how these white kids in this middle school and high school. But at that age, I didn't have the vocabulary to describe the injustice that was happening. I just viscerally felt it.
What can you be more specific? Like, what did you see or notice?
So when I was growing up in LA and SoCal, a lot of my friends were in gangs, and they're gang affiliated, selling drugs, they're around guns. And even at parties, when the police are called, there is a very different reaction when they're called to a party in LA or Anaheim or Santa Ana versus a police responding to a noise complaint in, like, say, Huntington Beach or some beach city.
Okay.
So the same conduct that they were doing in this middle class neighborhood that my friends and I were doing in this low income neighborhood, getting criminalized versus not criminalized.
So you witnessed that, and then how'd that lead you to going to law school and wanting to be a public defender?
So I went to an undergrad, a very liberal undergrad in the Bay Area, and I had a focus on racial justice issues, but I didn't know what public defense was. And then I majored in philosophy and gender studies, so I was super unemployable. So I went to law school. At law school, I took critical race theory, and I interned at Contra Costa Public Defenders my 1L summer and absolutely fell in love with it, and I never looked back. Because then I went to intern, Coco Puyi. And then I interned at Alameda PD, and then Sacramento PD, and then I did the whole interview circuit up and down California for a postmark position, and I got an offer from LA PD and San Diego Public Defender's Office, but I had to turn them down because of my wife. Exactly. And now we're hood defenders, like Dave said.
Defenders in the hood. I like it.
Yeah.
Well, cool. Well, great to meet you, Glenn. Thanks for coming on, reaching out to the podcast, and Lawrence, always great hanging out with you. Glad we can step away from the madness and get back in touch with why we do this.
Yeah.
So